Hi, thank you for joining our webinar today. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Denise Puente, a Louisiana construction lien law expert. Today's webinar topic is A Contractors, Subcontractors, and Suppliers Step-by-Step Guide to Getting Paid. So without further ado, I would like to introduce the fabulous Denise Puente.
Jessie, thank you for the introduction. As Jessie said, I'm an attorney with the law firm of Simone, Peragine, Smith, and Redfearn here in New Orleans. And in addition to having represented contractors, subcontractors, and suppliers over the years, I've also represented owners, sureties, and design professionals. So I have an appreciation for the need to get paid by every member of the construction team, as well as the desire by the owner to get their project finished. A couple of things before we start. I'm just going to go to my next slide. We're having a little bit of a technical problem here, but here we go. All right, if you have any questions, please go to the webinar chat box on the right on your screen, and we will answer the questions at the end. If you type a question, we ask that you not include your name or your company name so that it's more of a generic question. And I'll be glad to answer any questions you have related to any of the things we discussed here today. All right, the agenda for today is what I'd like to cover is your contract and important things you need to look at in your contract to determine what your lien rights and what you need to preserve those rights. We're going to go over public work contracts and private work contracts and projects because there are different sets of rules for liens depending upon what type of contract you're working on. And then we'll cover the basics of, who has lien rights and what you need to preserve those. And then finally, I'd like to finish up with lien waivers, because these are documents that are going to be included in your contract, and you want to make sure that you're not waiving your rights to preserve your lien or assert a lien or a claim on your projects. So first thing I'd like to cover is contract clauses. The important one to look for with regards to payment is pay if paid provisions or pay when paid provisions. And this type provision and the enforceability of this provision really varies from state to state. Pay when paid provision is the type of clause, and I've given you some examples here, where if you're a subcontractor supplier, you don't bear the ultimate risk of insolvency by the owner. So for example, if the owner does not pay the contractor money that's owed to you, after some reasonable period of time, that contractor is going to have to pay you regardless. So really the general contractor is the one that's bearing the risk of non-payment. What you usually see though in contracts and subcontracts is pay if paid clauses, where the provision says that if for some reason the general contractor does not pay you, then that general contractor does not owe you payment. The magic language is condition precedent. So you see the example here, it says that no payment, whether partial or final, shall be due unless and until, as a condition precedent, the general contractor receives payment. If you don't see that language of condition precedent or unless and until, then even though the general may think he has a pay if paid provision in your subcontract, it may not be enforceable. You'll notice that we also included the surety in that clause, and you want to make sure that you add the surety language to your clauses, because in Louisiana, a pay if paid clause is an absolute defense to payment by a general contractor. So if you have this provision in your subcontract, even if you did all the work, if the general wasn't paid, he will use this as a defense. However, it's not a defense to the surety company. So even though the general might not owe you payment, the surety would. However, what we see general contractors do now is include the word surety in their contracts, thereby becoming a defense as well to a surety company. Now, this might not be a big issue on, for example, a public project, because generally that money is allocated before the project starts. So it's more of a concern on private projects or projects that we call single purpose entity, where it's an LLC that has been formed solely for this project. Now, the other clause you want to look at is the right to stop work. So you want to be able to stop work or suspend work if you've not been paid by a certain amount of time. This is a good alternative clause to add if you have a pay if paid provision. So if the contractor says, look, I can't change it, I'm not going to change the pay if paid, I have in every contract, then you may be able to negotiate the right to suspend work until you get paid. This is what we try to do in general contracts with owners so that the contractor doesn't keep working even though they haven't been paid. The other thing you want to look at in your contracts is the notice requirements. And this goes more to claims, not necessarily for liens. But if you have to give notice within 21 days of something that might result in a claim, you want to make sure you give that notice. You want to see what's the method of notice. Do they accept electronic delivery of a notice? Or is an email sufficient? Or do you have to send it by certified mail? And it's also important to usually put it in writing. So you definitely want to look at what's your notice requirements in your contract so you're aware of what you have to do to comply to preserve your claims. Now, there's generally three types of contracts. There's public works contracts that are governed by the Public Works Act in Louisiana. There are private works contracts that are covered by the Private Works Act, and there are federal projects covered by the Miller Act. What I'm going to cover today is going to be primarily public works and private works, because those are the ones that we look at for liens and what we call statements of claim. For the Miller Act, the rules are slightly different, and it doesn't involve a lien. What it involves is a notice of a letter that you send to surety companies saying that you haven't been paid. Now, the Public Works Act. The Public Works Act governs those projects that are owned by a public entity, such as the state of Louisiana, the parish of Orleans, the city, particular city, a university that is a public university. So something like a Tulane University would not be governed by the Public Works Act, but a project at Louisiana State University, LSU, would be covered by the Public Works Act. So who has the right to file a statement of claim on a Public Works Act? And remember, on every public job, the general contractor by law is required to provide a payment bond and a performance bond. And so when you're making a claim on a public job, you are not liening the public building, because you can't do that. What you're basically doing is preserving your right against the bonding company. So for that reason, general contractors don't have what we're going to call claim rights on a public job. But subcontractors and subcontractors have it. Laborers of the contractor and the subcontractor have it. Material men, suppliers, lessors of equipment. So if you lease, construction equipment to a subcontractor, to a general contractor, you have rights to file a claim against that bond. Now, there's some specific requirements for lessors of equipment. You have to give notice when that equipment hits the site. You're supposed to give notice within 10 days, as we'll discuss a little bit later. If you don't give notice until after 30 days, your lien rights or your claim rights are only limited to after you give the notice. So what we often see is a standard letter from a equipment lessor that they send it, when the project first starts, they send it to the owner, they send it to the general contractor, just advising that they're leasing this piece of equipment for this project. Now, manned equipment is slightly different, and that's treated as almost like a subcontractor. And your lien rights or your claim rights are limited for equipment only to while the equipment is on site. And then the other person that has lien rights or claim rights on a public job are suppliers to subcontractors. Also included are transporters and architects and engineers that are hired by a contractor or sub. They also have claim rights. As I mentioned earlier, who does not have a claim right is a general contractor or suppliers to suppliers. That's why when we talk about manned equipment, it's important, because what we're saying is they're not they are a subcontractor to a subcontractor as opposed to a supplier to a supplier. Now, what has to be in a statement of claim? And remember, we call it a statement of claim because you're not liening the property. You're basically preserving your claim against the bond. You have to put the name of the party that's done the work, the amount that's owed. You have to identify the project so that when somebody runs a lien and privilege certificate on that project, they will know exactly what project you are liening. Obviously, you fall in the parish where the project's located. You don't need a legal description. So you just need, LSU Hospital, Main Street, Shreveport, or wherever it is. That's what you put in your statement of claim. You have to send it to the contractor and the owner, and it should be sent by certified or registered mail. Now, what's the time period for filing a claim on a public works project? It's 45 days after the recordation of either the acceptance or the termination. So on a public works project, it's easy because it's always the same deadline, no matter who you are, it's 45 days. If you don't file it timely and you're at a certain level, you could lose your right to file that claim, and it could be stricken from the record. A seller of movable and equipment seller, or some other movable supplier, they have to give notice within 75 days of the end of the month for each month that they're not paid. So that's almost a prerequisite to filing the claim later, giving these notice of non-payments. And it's important because if you don't give those notices, then part of your claim can be stricken because you did not provide the timely notice. The time period to file suit, it's 1 year from the recordation of the acceptance of the project, or if there's a default from that 1 year, all right? So remember, you have 45 days to file your claim from when they record the acceptance. You can file it earlier, but you only have 1 year from when that acceptance date is to file the lawsuit. So if you file your lien, on day 10 after they recorded the acceptance, you're going to have more than just 1 year, because it's going to be 1 year from the recordation of the acceptance. And then finally, on all public jobs, one of the prerequisites for the general contractor to be paid is to provide to the owner what we call a clear lien and privilege certificate. So they have to show the owner, look, there's no claims filed on this, for the owner to release the final payment, the retainage, to the general contractor. Where there is claims recorded, they then have to bond out those liens. And so to bond out the lien, they get a surety company to provide provide a bond, and that bond amount has to be 125% of whatever the claim is that you've recorded. Now, sometimes you will record a claim and then you'll get what we call the 10-day letter, which is at 2242.1. And that's a demand on you to cancel your claim for some reason that it's improper. For example, if it was filed too late, they're going to say, hey, if you don't cancel it within 10 days and we have to cancel it or we have to take other action, then you're going to be responsible for the damages incurred and the legal fees incurred in taking that action. Now, if the amount is incorrect, that's not a basis under 2242.1 to require you to cancel the lien. It really is procedural things, like it's the wrong project, it's been filed too late, things like that. So if you get a 10-day letter, you got to really look at it to see and check your lien to make sure that you've complied with the statute. And so once the owner gets the clear lien and privilege, even if you haven't been paid, if your lien was bonded out or your claim was bonded out, then the owner is going to go ahead and release the remaining funds to the general contractor. Now, under the Private Works Act, that covers the projects where the owner is, we see it like on condominium projects or residential, hotels, anything, even though there may be some public money involved, there may be some tax credit project, things like that, it's still going to be governed by the Private Works Act. The Private Works Act is a little bit trickier than the Public Works Act. Now, the first thing, if you get nothing else out of this seminar today, the most important thing if you're a general contractor is that you have got to record a notice of contract if your contract is worth more than $100,000. If not, then you're not going to have any lien rights as a general contractor. And it also affects the time period for subcontractors and suppliers to record their liens against the job. The Private Works Act, you do lien the property. You do get a claim against the actual physical property, the project. So the notice of contract should identify the owner and the contractor, contain a legal description. This is critical. It cannot just be a municipal address. It's going to say payments will be made on a monthly basis upon submission of a payment application. Generally describes the work, construction of a hotel, renovation of an apartment complex, you know, and it's signed by the owner of the contractor. And if a bond was required on a private works project, that bond is usually attached to the notice of contract. A bond is not required by law on private jobs. Owners do it to protect themselves from claims by subs and suppliers. And also performance issues if they require a performance bond. Now, who can be a claimant? It's pretty much the same people as the Public Works Act, except for general contractors. Remember, generals don't have claim rights on public jobs, but they do on private. Same thing, suppliers to suppliers do not have lien rights under the Private Works Act either. This gives you sort of a overall look at what's covered by your lien. If you're a sub, it's for the price of your work. For laborers, it's, you know, their wages or whatever they earned while they were at the site, all right? Sellers of movable, it's if either it becomes a component part of the project or if it's consumed. So for example, nails, things like that, even though they may get lost or maybe you can't see them, they're consumed in the project and so they are covered. Lessors for the equipment while it is on the site, and it's got to be leased by a written agreement. And then we have architects, engineers, etc., as we did on the Public Works Act. Okay, the notice requirements. This is the little tricky part of the Private Works Act. If the notice of the contract is timely filed by the general contractor, meaning before they start work on the job, then a general contractor has 60 days to file a lien. The substance suppliers only have 30 days. And that is that 30-day period and that 60-day period run from the recordation of the acceptance of the project. Now, if the project's abandoned and no notice of acceptance is ever filed, then you are substantially complete and no notice is filed, then you would have, I'm sorry, you still have 30 days, but it doesn't run for the 6 months after substantial completion when there's an abandonment. Now, if the notice of contract is not filed, then the general loses their lien rights and the subs and suppliers actually have 60 days. But I always tell clients, look, it's better safe to be sorry, so always file within 30 days and you don't have an issue. Now, when does the period begin to run from under the Private Works Act? It runs from the recordation of acceptance or the recordation of a termination. And as I said earlier, if there's no acceptance filed, then you have 6 months from the substantial completion of the job or abandonment to record your claim. The lien contents. You identify, you know, who provided the work. So you identify your the subcontractor's name. You put forth who owes you the money. So it's the general contractor. You identify the project. So for example, construction of hotel at 123 Main Street. But you've got to include the legal description of the project. So you can't just say 123 Main Street. You usually say as more fully described as, and then you have lot and square, whatever your legal description is. You do not have to attach your invoices that are outstanding. But if you put in there you're owed, $150,000, as provided in the attached invoices, and forget to attach your invoices, then your lien's not going to be valid. So you don't have to attach the invoices, and it's probably simpler if you don't, but you have to spell out what it is that's owed to you and what work you performed. And it's got to be a sworn statement, so it's got to be notarized. The lien does. The time period to file a lien the time period to file suit under the Private Works Act is 1 year from the deadline to file a lien. So if it's 30 days to file a lien because the notice of contract was filed, then you have a year from the expiration of that 30-day period. Now, a couple of tricky ones under the Private Works Act. For example, if you are a lessor of equipment, any type of movable, you have to deliver the notice of non-payment to the owner. I'm sorry, you have to deliver notice of, it's not non-payment, notice to the owner that you're going to deliver this equipment within 10 days of when it first hits the site. The notice, and that's what we talked about before, it should say, you know, who you're leasing it to, what's the equipment that you're leasing, what's the terms of the payment, and it's got to be signed. So normally what we see is a letter which just attaches a copy of the lease, and that's what's sent to the owner and the general contractor, all right? If you deliver that notice more than 30 days after the equipment has been placed on the site, then the claim's only going to be limited to the rents that accrue after the notice. If you do it from the beginning, then it's going to cover all of the rents that accrue throughout the project. Now, the non-payment for the sellers of movables we discussed earlier is 75 days from the last day of each month that you provide the materials. So if they haven't paid you for 4 consecutive months, you should be providing 4 consecutive notices. If you only provide the last 3 or you provide 1 and it covers 2, but it's okay, then that's fine. But if it's more than 75 days from the last day of the month, then you're going to be precluded from recovering that amount that's outside of that 75-day period. The notice should include, you know, obviously your name, description of the equipment that you have sold to them, the legal description of the project, and the amount that's owed. And the last thing I wanted to cover is lien waivers. When you are looking at your contract, when you get your subcontract, I always recommend that you prepare a cheat sheet. You read the contract, you look at what are my deadlines to provide notices, when do I submit pay applications, what has to be included with my pay applications, is it backup, things like that. And often you will see in your contracts a form of lien waiver. And what that lien waiver, there's 2 types. Usually it's the type that you release all your claims through the date of the payment application. All right, so generally I submit my pay up on the 20th, and that lien waiver says that I'm releasing it all through the 20th. All right, or sometimes it releases it through the date of the waiver, which is a later date. You want to look at 2 things. You want to make sure that it carves out and you reserve your rights for retainage. And if you have any outstanding claims, sometimes you have to identify those claims, because what you don't want is, you don't want to get through the whole project, make a claim at the end, or try to lien for some amount of the money at the end of the job, only to find out that you waived all those rights when you were submitting these monthly lien waivers. So it's really important to look at and read the lien waivers and understand what it is that you're waiving when you sign these lien waivers. Generally, what we also try to do is make the lien waivers release from the previous month, because you already gotten the previous month's payment. Generally, what happens is you have to submit a lien waiver with your current payment application, but you haven't gotten that payment yet. It's going to take, 30 days to get it. So you can either change it to make sure it's conditioned upon receipt, I hereby waive, whatever, or that the waiver is just through the previous month's payment, because you theoretically would have gotten the payment by then. So that's pretty much an overall view of lien rights and how to secure them under both the Public Works Act and the Private Works Act. And I'll now turn it back over if anybody has any questions. And if not, I'll turn it back to Jesse.
Well, first of all, thank you so much, Denise. That was wonderful. You packed a lot of information in there for us. I do have a question that came through. I think you kind of already have touched on it a little bit, or right here at the end. It says, does Louisiana have a standard form for their lien waiver?
No, there's no statutory form for lien waiver. There's several different versions that you see in contracts, but there's no statutory form. So it just depends on the contract that you get, what lien waiver that particular contract's going to be using.
Perfect. And I think right here at the end, you also did, speaking about the lien waiver, there's a follow-up question about it. It's asking if there's any specific language that needs to be added on there for conditional or unconditional release. And I think you put on there, even said conditioned upon receipt might be a good term to kind of make sure you're including.
Correct. And or look at it to see if it's not conditioned upon receipt of the previous month's payment application, which you theoretically would have gotten. But that's what you want to make sure, that it's conditioned upon receipt of payment. And I've even seen some generals will use 2 forms. They make you sign unconditional, like if I submit my pay application today and we're March 21st, I'll have 2 lien waivers with that pay application. One is the unconditional in connection with the payment I received last month, And then the other one is conditional for the application I'm currently providing. So it's conditioned upon me actually getting the money to release it. The claims, but for anything before that, I've already been paid.
Perfect. And then one other question came through, Denise. It says, how long is my lien effective?
Well, you only have the 1 year to file suit. So your lien is only effective if you file that suit to preserve it at the 1 year. So if it gets bonded out before that, you don't have a lien on the property, but now you have a claim against the release of lien bond surety. So you can let your lien sit on that property, but you got to make sure you file suit within 1 year, depending on whether it's public or private. And if not, then you lose the lien. And somebody can come in after the fact and just have it canceled by a judge, even though you're not agreeing to it because you didn't preserve it in a timely manner.
Okay. Right. So you guys, these are really important things to pay attention to. Make sure that you're not letting your lien stay there and not filing suit on it if you need to. And then also make sure you guys are really reading any waivers and releases before you sign them. Pay attention to any legal language on there that's not going to be in your favor. All right, so I think that's all of the questions that were posed on here. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. All right, so who is ready to win a gift? So take a look at this little pop quiz we have on here. We've got 2 questions. I know Denise already went through a lot of this information, so take a look. If you know the answers, go ahead and you can chime in, answer it in our little chat here, and I will send you guys over a little gift. All right, can you go ahead and go to the next slide for me, please? Okay, so right here, we've got some SunRay resources to help you guys stay organized, know your deadlines, and secure your lien rights. Go ahead and scan that QR code to access these incredible resources. We've got deadline calculators, project information sheets. There's the lien law rules by state. So let's say you're working in Louisiana, you can pull up all of that. If you're working in one of the other nearby states and that's where your project is, every state has their own lien law rules. So make sure that you're checking on there to make sure that you're staying timely and sending in the correct documents. Can you go ahead and go to the next slide for me, please? All right, so SunRay has a new service. So we are offering collections. It's SR receivable. So we will help you with your collections and get you guys paid. So please reach out, give us a call, send us an email, and we will let you know what we can do for you. Go to the next slide, please. All right, our next webinar that we have, it's actually with one of Denise's colleagues, Ben Grau, and he is going to be going over some more Louisiana lien law. It's going to be, don't sign a release unless it says this one thing. That's going to be May 9th. So go ahead and sign up for free at sunraynotice.com/education. We'd love to see you guys there. Next slide, please. All right, here is a Google review. If you guys can scan this QR code, give us a review, let us know some feedback. We really appreciate any of the feedback. It helps get some information out there to other contractors and suppliers like yourselves. We really appreciate it. All right, next slide. All right, and then with that, that is all we have for you guys today. Thank you again for everybody that attended. We hope to see you guys at our next webinar. Denise, thank you again. You were incredible. I hope you all have a wonderful and beautiful sunny day. Thanks again, everyone.